Good afternoon, Judge. My name is Chris Carroll, and I'm here to present arguments to support the inclusion of evidence obtained from a fire resulting at 614 Mays Street. I was contacted as a fire investigator. Upon my arrival, the family and fire crews were gone. I made entry into the structure to begin my investigation. I began by photographing the structure from the exterior to the interior. While examining some of the evidence, I noted that personal items appeared to be missing, and the house appeared to be staged with old furniture and a broken TV. Upon further investigation, I noticed some type of device melted behind the TV. As I collected the melted device, I saw what appeared to be a pour pattern behind the TV towards the kitchen. As I was finishing up my documentation, the homeowners returned to the scene with their attorney. The attorney stated that I made entry into the residence without permission, and any and all evidence collected must be suppressed due to the chain of custody. The defendant's attorney then stated the evidence obtained was in violation of the homeowner's constitutional rights, including the Fourth Amendment right against warrantless searches and seizures. I then introduced myself, noting that I was the fire investigator for XYZ Insurance Company. I submit that the motion to suppress this evidence be overruled and included in these proceedings. The basis for this is that the insurance policy is a legally binding contract. Within this contract on page 5, paragraph 3, is the clause titled Duty to Permit Inspection. It states that there are 3 separate duties to permit inspection under the policy. The first requires the insured to permit inspection of the damaged property site where the loss occurred. This includes a requirement to permit access to the fire scene for the origin and cause determination and related activities. The second includes a duty to permit inspection of the damaged personal property, equipment, inventory, and other items from the fire scene, especially anything which may have been removed from the fire scene afterward by the insured. The third type of duty to permit inspection relates to the insured's books and records. I submit to you, Your Honor, that this is not a case of Fourth Amendment right against warrantless search and seizure, but merely the execution of a valid contractual agreement. The insurance investigator is the only way that I can think of to allow the evidence to be utilized as evidence. If the insurance investigator shares evidence found with the public sector, they can do so without threat of civil suits or punitive damages via the Arson Reporting Immunity Bill. Now, if I'd been the investigator for the fire department, I'd be required to obtain consent to investigate for cause and origin. In the event consent is not provided, then an administrative search warrant must be obtained. During the investigation to cause and origin, if probable cause is believed, the investigation will halt and a criminal search warrant shall be obtained. The crew leaving the scene unsecured interrupted the chain of evidence. Someone is required to stay on the scene, ensuring the chain of evidence until the fire marshal can arrive to begin the investigation into cause and origin. Court cases that are relevant include Michigan v. Tyler and Michigan v. Clayton. Michigan v. Tyler defines entry for cause and origin via an administrative search warrant. Michigan v. Clayton defines a criminal search warrant to find evidence of a crime. Demonstrative evidence was a picture of a pour pattern. References are below. Thank you.